Thank you, my lord.
Yes. No appearance for the defendant.
Maybe they didn't appear, my lord.
Yeah,
My lord, I forwarded it to them.
You said?
I forwarded the message personally to Barrister Udonse for the defendant.
Yeah, I think he has left. He is no longer handling the case.
That of Uwem, the lawyer that appeared the last time, I checked the process. I couldn't find his number. It's only that of Udosen that was there.
Udonsi.
Because
Okay.
we have to serve them. We serve them properly.
Okay, my lord.
Is it the address you serve? Is it the address on their process?
Yes, my lord. Is the one at the one here in Calabar.
Okay.
Yes, my lord.
I hope you have proof of service.
My lord, I do.
Yes, this is the judgment of the court. On the 24th day of September 2021, the claimant took out a general complaint wherein by the paragraph 45 of the statement of claim, the claimant claimed against the defendant jointly and severally as follows. There are 12 reliefs. I have reproduced the reliefs, so I will keep reading them. A reaction to the claim of the claimant, the defendants on 9th day of June 2022 filed joint statement of defense. In response, the claimant on 21st day of June 2022 filed reply to the joint statement of defense. The claimant testified in proof of his case as CW1. He tendered documents that were admitted in evidence and marked as Exhibit C1 to C33. He was also cross-examined by the counsel for the defendant. Thereafter, he was discharged. The defendant called two witnesses in proof of the case of the defense. The first witness was the fourth defendant in this matter, DW, who testified as DW1. DW1 did not tender any document in evidence, while DW2, who testified as second defense witness, tendered 3 documents which were admitted in evidence and marked as exhibit: DW2A, DW2B, and DW2C. The witnesses of the defendants were at the end of their respective state testimonies cross-examined by counsel for the claimant. Thereafter, they were all discharged. The case of the claimant, I will keep reading it. When counsel gets the hard copy, he will see. I have also captured the case of the defendants, so I will keep reading it. I have also captured the reply by the claimants to the joint statement of defense. I will also keep reading it. Then the submissions of the defendants, they formulated 5 issues for determinations, but in their argument, they collapsed them to 4 issues. I have captured the argument of the issues in the body of the judgment, so I will keep reading that. Then the submission of the claimant formulated only a single issue, which has been argued, and I have captured the argument on the first issue in the body of the judgment. So I will now go straight to the judgment of the court. I have considered the processes filed by the parties and taken close look at the pleadings and evidence adduced by the parties. I have also taken time to scrutinize the several documents tendered and admitted in evidence. On the 17th day of July 2025, when this matter came up for adoption of final written addresses, the Defense Council, the Dependents Council, the dependents and their counsel were not in court. Consequently, pursuant to Order 45, Rule 7 of the rules of this court, the final written address of the defendants filed on the 16th day of January 2025 was deemed as having been argued and adopted. I have decided to in extenso state the facts of this case as disclosed by the pleadings of the parties and the evidence contained in the witness statement on oath due to the intricate nature of the facts culminating into the filing of this suit. The claimant, as per paragraph 45 of the statement of facts, is claiming for a total of 12 reliefs. It is clear to me that the main thrust of the case of the claimant is contending the validity of his dismissal from service without giving him fair hearing, which was communicated to him verbally by the third, fourth, and fifth defendant on the 19th and 21st day of July 2021. The final written address of the defendants, 5 issues were formulated for determination. However, issue 1 and 2 seems to have been fused together and modified. They become one issue, as can be seen in the argument presented in the final written address of the defendant. For the claimant, a single issue was formulated for determination. I have herein before captured the argument advanced by counsel in their respective final written addresses presented before the court. The claimant's 12 reliefs have also been reproduced in the earlier part of this judgment. I shall start by considering some preliminary issues raised in the joint statement of defense. The defendants have stated that they will contend during the defense that the fourth and fifth defendants were wrongly joined as parties in this suit. They also stated that the claimant has not observed the pre-action notice protocols before instituting this action. They also state that the case of the claimant is statute bar having been filed outside the 3 months limited or period provided for by Section 2A of the Public Officers Protection Act. See paragraphs 17, 18, and 19 of the joint statement of defense. It appears the fourth and fifth defendants have abandoned the idea mooted in their defense to contend that they were wrongly joined as parties in this suit, as they decided not to raise any objection or advance any argument in that respect in their final written address. In these circumstances, the allegation of being wrongly joined has been abandoned, as even the fourth defendant appeared and testified in the defense of the defendant. On the alleged lack of compliance with the action notice protocol, even if no pre-action notice was served on the defendants, it cannot be a success story for them because a pre-action notice is not in the nature of jurisdictional issue that cannot be waived. The great jurist of blessed memory, Justice Ayola JSC as his name was, has expounded this principle in the case of Mobile Producing Nigeria Unlimited versus Lagos State Environmental Protection Agency and others, where the apex court held a pre-action notice which is for the benefit of the person or agency on whom or on which it should be served is not to be equated with processes that are an integral part of the proceeding initiating the process. As has been said in the number of authorities, its purpose is to enable that person or agency to decide what to do in the matter, to negotiate or reach a compromise or have another hard look at the matter in relation to the issues and decide whether it is more expedient to submit to the jurisdiction and have a pronouncement on the point in controversy. The law is clear that conditions imposed for the benefit only of a particular person or class of persons can be dispensed with. End of quote. Per Ayola JSC. The defendants did not raised the issue of non-service of pre-action notice timelessly, and therefore they are deemed to have waived it on the allegation that the claimant suit is started. They have waived it, and it therefore failed. The said issue failed and is hereby refused. On the allegation of that the claimant suit is started by, in order to determine whether an action is started by or not, the court examines the originating process, the statement of claim, together with the evidence or record, so that the court knows for certain when the wrong complaint occurred, which would be contextualized with the date the originating process was filed. See the case of Asaboro versus Pan Ocean Oil Corporation Limited. See also Ogundife versus NDIC. In this case, the claimant alleged that his dismissal was communicated to him verbally by the third, fourth, and fifth defendant on the 19th day of July 2021. The defendants on their own never stated the date on which they dismissed the claimant from service, nor did they tender the dismissal letter which they said they have served the claimant. In the circumstances, the course of action in this case accrued on the 19th day of July 2021, when the claimant becomes aware of the dismissal. And this suit was commenced on the 24th day of September 2021, counting from 19th day of July to 24th day of September 2021 is a period less than 3 months. This means that the claimant filed its action within the time allowed by the law. Therefore, the objection on statute bar also failed. Same is hereby dismissed. Also, in the address of the defendants on the efficacy of Exhibit C7 and C28 tendered by the claimant in evidence, according to the counsel for the defendants, the medical report from University of Calabar Teaching Hospital, Exhibit C12, endorsed by Dr. Inkang Efe, appears illusory and deceiving to deceive the court. For counsel, the wounded legs pictures seems to be a film trick and has a serious doubt to the mind of any reasonable person. They also considered it to be an afterthought. Counsel also argued that the pictures, three photographs, they sound funny and ridiculous. Let me at this juncture, before returning to the preliminary issue, that the counsel stated that the counsel for the defendant has, in the final written address, made reference to writ of summons. By the rules of this court, writ of summons is not one of the methods or one of the stipulated methods of commencing an action. By the rules of this court, the appropriate process is general form of complaint. See Order 3 of the National Industrial Code Civil Procedure Rules 2017. Counsel has also made reference to wrong exhibit. For instance, reference to Exhibit C27 was not correct. The correct exhibit as marked by the court is Exhibit C28. Counsel has in his address made reference to Exhibit A1, A1, A2, and A3 when there were no exhibit with such marking by the court. There were also typographical errors in the address. I need to reiterate here that counsel, when preparing court processes or filing in court, is expected to be circumspect and ensure that any process meant for filing before the court have least or no mistake or errors. The reference to some sections of the law also were also not correct. Now, coming to the preliminary objection on Exhibit C7 and C27. Ordinarily, the test for admissibility of evidence is relevancy. Section 1 of the Evidence Act 2011 as amended provides, in fact, that evidence may be given in any suit or proceeding of the existence or non-existence of every fact on issue, and of such facts as are hereinafter declared to be relevant, and no other. See Section 4 to 10 of the Evidence Act 2011 as amended. Section 5 of the Evidence Act also provides The facts which are occasion, cause or effect, immediate or otherwise, of relevant facts or facts in issue, or which constitute the state of things under which they happen, or which afforded an opportunity to their occurrence or transaction are relevant. Then Section 10 provide in proceeding in which damages are claimed any fact which will enable the court to determine the amount of damages which ought to be awarded is relevant. See the case of Omega Bank Nigeria Limited PLC versus OBC Limited. See, however, for a document to be admissible in evidence, it must be pleaded relevant and legally admissible. See the case Udoro and others versus Governor of Akwa Ibom State. There is no doubt the medical report from University of Calabar Teaching Hospital on the claimant's sickness was pleaded and relevant to the claimant case. See paragraph 31 of the statement of facts. In view of my finding, FBC 7 is admissible and was properly admitted in evidence. However, admissibility is one thing and probative value is a different matter entirely. Admissibility precedes probative value, and the fact that a document has been received in evidence does not necessarily mean that it has the weight of admissibility. It has the weight. Admissibility is based on relevance, while probative value depends on relevance and proof. See the case of Imangri versus Akote and others. See also the case of UTC Nigeria PLC versus Lawal. The document is a medical report from University Teaching Hospital signed by Dr. Ekan Epe. The document was tendered by CW1, who is the maker, who is not the maker. The maker of the document, Dr. Ekan Epe, was never called as a witness in this case. This means Exhibit C7 can only serve as evidence that a medical report was issued, but it cannot be proof of content of the said exhibit. On Exhibit C28, 3 pictures or photographs were tendered in evidence by CW1. He is not the taker of the photographs. The person that took the photograph was never called as witness in this case. Since the appropriate person to testify on the authenticity of these photographs has not been called as witness, the court will not be able to give credence to what the documents were tendered to prove. I now turn to the determination of the dispute between the parties. It is elementary that he who asserts must prove, see section 131, 132, 133, and 136 of the Evidence Act as amended, and the case of Lare Kore Limited versus Asho and others. The claimant must satisfy the court that he is entitled to judgment on his claim, failing which the case will be dismissed. Also, the claimant who seeks declaratory relief must establish his entitlement to the declaration by credible evidence and will succeed on the strength of his case, not on the weakness of the defense or admission by the defendant. The rationale for this is that in declaratory relief, the claimant seeks to exercise the court discretion in his favor and must place sufficient materials before the court to justify the exercise of the discretion in his favor. See Indul Wayo and others. See Undul versus Wayo and others. See also Osho and Adeleye and others. However, the burden of proof is not static. See section 133, subsection 1 and 2 of the Evidence Act as amended, and also the Sprunket of Indul Wayo cited supra. Kekere Okun JSC, now CJN, where the learned justice held. Thus, the general rule is that he who asserts must prove. The burden is therefore on the plaintiff to first adduce prima facie evidence in support of his case. Where a prima facie case is made out, the burden shifts to the defense to adduce counter evidence to sustain their defense. Where an allegation is made positively or negatively, and it forms the essential part of a party's case, the proof of such allegation rests on him. However, the evidential burden of proving particular fact may shift throughout the proceeding, so the burden of proof shifts in two circumstances, where the claimant discharges the initial burden of proof, which rests on him by section 131(1), amended as the Supreme Court held, made out a prima facie case. Then the burden shifts to the defendants to adduce evidence in support of their defense. The second situation is the evidential burden of proving particular facts in line with Section 136 of the Evidence Act. Therefore, until the claimant makes out a prima facie case, there is nothing for the defendant to rebut. In employment dispute, the court usually refers to the employment contract and any other stipulation incorporated or deemed to have been incorporated into the contract. See the case of Bedu and others versus ET and others. See also German and others versus Delta Steel Company Limited, and the case of Adekule versus United Bank for Africa PLC. The contract of employment is the bedrock on which the parties to an employment contract found their case, and the success or failure of the case depend entirely on the terms agreed or deemed to have been agreed by the parties. See the case of Omera versus Nigeria Railway Corporation, where there are many documents incorporating the terms of condition of employment. The court will not look outside those terms as disclosed in the document in deciding the rights and obligation of the parties. See Juan and others versus Delta Steel Supra. In the case at hand, Exhibit C2, which is the letter of employment of claimant, has unequivocally stated that the employment of the claimant will be subject to terms and conditions laid down for the Federal Public Service of Nigeria and the Civil Defense Immigration and Prison Service Board rules and regulations on appointment, promotion, and discipline. It was also stated that at any time, claimant may terminate his engagement by giving 1 month notice, a right to or with the consent of authority of in lieu of notice. A law and employment can only be either one of master and servants or governed by statute, thereby giving it a statutory flavor. An employment is that of master and servant if the relationship between the employer and employee is governed by the written contract between the parties. Thus, in determining or construing the terms and conditions of employment relationship between parties, it is the written contract existing between them that the court will look at in other words, if any dispute arises with respect to the contract, it is the terms and of the contract document that will act as a guide to the construction of the relationship between the employer and employee. See Kado versus CBN. See also Federal Civil Service Commission versus Lawe, and Shitabe versus Federal Public Service Commission. An employment with statutory labor, on the other hand, is one which conditions of appointment and determination are contained in the enabling statute that created the employer, and which contract is determined not by the parties but only by the conditions stipulated in the governing statute. Thus, a contract of employment of personal service, otherwise known as master and servant relationship, is one which can be determined unilaterally by the parties according to the terms of the contract or by the agreement of the parties. In a contract of employment enjoying statutory labor, a breach of the enabling statutory provision cannot result in unilateral repudiation, as to do that will be ultra biased, null and void. Thus, a contract of employment with statutory labor has the terms or conditions of appointment or determination stipulated in the enabling statute that created the employer, and the contract can only be validly determined according to the precondition stipulated in the statute. See the case of Pakwade versus OAU Teaching Hospital. See also NTMB versus Inoli. See also Adeni versus Governing Council, Yaba College of Technology. See OAX Pension Limited and others versus Michael Oladipo Olayinka. See Olariwaju Olaruntoba Oju and others versus Abdurrahim and others. See also University of Maiduguri Teaching Hospital Management Board versus Dawa. Thus, in power holding Company of Nigeria PLC versus Mr. IC Opiolo, the Supreme Court found Mohammed JSC as season was held as follows. I need only to reiterate the position of the law that which has for long been settled in litany of cases that the mere fact that an employer is a creation of statute, whether it is statutory corporation or that the government has shares in it, does not elevate its employment into that of statutory labor. Rather, there has to be a linkage or nexus between its employee appointment with the statute creating the employer or corporation. Earlier on, in the case of Pakwade versus OAU, the Supreme Court held that the character of appointment of and statute of employee, irrespective thereof, is determined by the legal character and the contract of the employee. Hence, where the contract of appointment is determinable by agreement of the parties, simply there is no question of contract having a statutory flavor. The fact that the other contracting party is a creation of statute did not make any difference. From the above exposition of the law, it is clear that the distinction between contract of employment with statutory labor and contract of service is paramount, is of importance in the resolution of dispute between the parties. What is clear from the distinction is the difference between the contract of personal service and one with statutory labor is merely one of the legal consequences in the event of a breach. Thus, a breach in the statutory provision relating to the termination or dismissal of employee who is statutorily protected will mean that such termination is null and void, and the contract regarding its subsistence. In such a case, the court may declare that such employee be reinstated. A breach of a contract pursuant to personal service, which is subject to the incidence of master-servant relationship, will not lead to the reinstatement of the employee unless in very special circumstances, considering the facts and circumstances of the case. See Chukuma versus Shell Petroleum and Oporishi versus Nigerian Gas Company Limited. Also, Ricard Obibi and others versus Delta Steel Company Limited Supra. It is now a well-established principle of law that when an office or employment has a statutory labor, in the sense that its conditions of service are provided for and protected by statute or negotiation made there under, any person holding the office or is in that employment enjoys a special status over and above the ordinary master and servant relationship. In the matter of discipline of such a person, the procedure laid down by the applicable statute or regulation must be fully complied with. If materially contravene any decision affecting the rights or reputation of the tenure of office of that person, may be declared null and void in an appropriate proceeding. See Shitabe versus Federal Public Service Commission. See Olanian University of Lagos. See Epereku University of Lagos. See Olatibosun versus NISA Council. In the case at hand, the claimant's employment was made pursuant to the Repeal Prison Act. In the schedule to the Act, prison regulation, which is a subsidiary legislation, has made ample provision for taking disciplinary action against an employee. Also, the public service rules have provided on disciplinary action against employee who has committed act of misconduct. The public service rules having been made pursuant to the Constitution, any appointment being governed by it enjoys statutory labor. See the case of Controller General of Customs versus Gusau. Therefore, for any disciplinary action to be taken against the claimant, such action must be in line with the laid down procedure prescribed by the rules. In other words, any disciplinary action to be valid, it must be in conformity with the rules and regulation, telling which the disciplinary action will be declared null and void. The claimant's employment being one that enjoys statutory labor, for any disciplinary action to be taken must be based on strict compliance with the laid down procedure for taking disciplinary action as contained in the statute and the public service rules. In determining contract of employment with statutory labor, compliance with the procedure laid down is the condition of service is mandatory. Any deviation may render the exercise futile. See the case of Shitabe versus Federal Civil Service Commission. See also the case of Lawe versus See also Pereku versus University of Lagos and CBN versus Iguelu. See also Bamboy versus University of Ilorin and Olorin Toba Oju versus University of Ilorin. Controller General of Customs versus Gusau. The claimant has insisted that he is a staff of the first defendant and entitled to the salaries and allowances and sundry benefits accruable to staff of the defendant. This means he is claiming that he is still in the employment of the defendant, as his purported dismissal from service was a nullity due to non-compliance with procedure for dismissal as laid down by the rules and regulations governing the employment. He also stated that the dismissal was done without affording him a fair hearing and was communicated to him verbally by the third, fourth, and fifth defendant on the 19th and 21st day of July 2021. He is also seeking for order compelling the first defendant to approve his application for voluntary retirement from service. The defendants have in their reaction stated that the process was followed, due process was followed in dismissing the claimant from service as according to them, he was served with Form 69 charge sheet for absenteeism from 19th day of January to 2015 to 5th day of July 2018 without permission, contrary to the provisions of Regulation 82E of CAP 29 laws of the Federation of Nigeria, which was the law as at 17/9/2018. The claimant should also be made to work for a reasonable period of time from there he deserted from before any transfer. He should also seriously be cautioned on his attitude to duty. See Exhibit DW2C. The investigation and finding of disciplinary action against the claimant. See also the investigation and finding of disciplinary action against the claimant. See Exhibit DW2B and DW2A. The claimant in his reply to the joint statement of defense has maintained that he was never afforded fair hearing and he was never served with any charge sheet, query, or charge on alleged absenteeism. On the face of the denial by the claimant of not appearing before it is incumbent on the defendant to adduce evidence showing that the claimant was indeed queried, served with the alleged charge of on absenteeism. They are also duty bound to adduce credible evidence showing that claimant was in fact served with hearing notice for the disciplinary action. Exhibit DW2A, DW2B, and DW2C tendered in evidence by the defendants are not capable of proving that the claimant was indeed served with any query or charge on allegation of abandonment. They are also duty bound to adduce credible evidence showing that the claimant was in fact served with the hearing notice for his disciplinary hearing. Exhibit DW2A, DW2B, DW2C, tendered in evidence by the defendants are not capable of proving that the claimant was indeed served with any query or charge on allegation of absenteeism, or he was issued with hearing notice for the disciplinary proceeding. For the defendant to discharge this onerous burden, they are required to bring evidence showing service on the claimant of the charge, query, or hearing notice for hearing of the disciplinary proceeding. It is tried to know that he who asserts the positive must prove. Thus, the onus is on the defendant to assert positive assertion that he was indeed queried, served with the charge, and with the hearing notice for disciplinary proceeding against for disciplinary proceeding to prove such service on the claimant. Now, the law is that where there is dispute as to service of documents, such can only be proven to have been served by evidence of a dispatch rider's book indicating receipt of the said document. B. Evidence of dispatch by registered post. C. Evidence of witness credible enough that the person was served with the document, or evidence of the witness who had effected the service. See O'Malley versus Federal Polytechnic, Kaduna, and others. See also the registered trustees of the Apostolic Church versus if said exit of a witness who did not effect the service is not enough to establish or prove service of query, charge, or hearing notice of disciplinary proceeding. There is no evidence before this court that claimant was ever invited to the disciplinary committee or that the claimant was served with alleged charge on which he was purportedly tried and found guilty, or even served with any hearing notice. In the circumstances, this court cannot believe the position of the defendant, since there is nothing before the court to show that claimant was served with invitation to appear before the disciplinary committee, or was served the document said to have been allegedly served on the claimant. There is no evidence of confirmation of the said delivery or service on the claimant. DW1 has stated under cross-examination that the claimant was issued one query between September and November 2018. However, he also stated that the query is with the court. I have scrutinized all the documents tendered and admitted in evidence by the parties. There is no query among the exhibits before the court. It is surprising to hear that from DW1 when throughout his testimony he did not tender any document in evidence. I wonder how such query will be with the report. To make matters worse, when asked which exhibit is it, he said he does not know which exhibit the query was. On invitation of claimant to appear before the disciplinary committee, he said he does not have the invitation. The claimant has also denied being served with letter of dismissal from service. It is noteworthy that DW1 even stated under cross-examination that he does not know who served the claimant with the letter of dismissal, but he was told claimant was served. DW1 also stated he cannot remember the date of dismissal. It is clear from DW1 evidence under cross-examination that his evidence is hearsay because he was narrating what was told to him. The absence of an acknowledgement copy of the said letter of dismissal was purportedly said to have been served, which has been purportedly said to have been served on the claimant, goes to show that claimant was never served with any letter of dismissal. That's why the defendant could not claimant was not communicated with the purported letter of dismissal, but he was told verbally in 2021 of the purported dismissal. The law is that a unilateral termination of contract of employment, more particularly one with statutory labor, see also the case of Mobile Producing Nigeria Unlimited versus Udo in PHCN versus Opoilo. It was stated proper communication of a message in law has its importance. Where there is a failure to communicate, a break in communication, or lack of communication, the whole purpose of message is completely defeated. If any step or action is taken by the issuing authority in spite of the fact of non-communication, non-service, the step or action taken goes to naught and amount to a nullity in law. See also UBA versus Ayambade. In various places, the claimant was not served with the with with a query or charge based on which he was allegedly tried and found guilty and verbally dismissed. His dismissal is in violation of the law and it renders it null and void and of no effect whatsoever. The effect of the above finding is that the purported verbal dismissal of the claimant is not capable of determining the claimant's employment. The said dismissal is allowed, is invalid, null and void, same ought to be set aside and is hereby set aside. It is to be noted that dismissal of an employee is a disciplinary measure in the hands of the employer, which an employer disciplinary in the hands of the employer when an employee commits an act of serious misconduct. The power, the power to dismiss, the power to dismiss is a power exercisable by the employer without a corresponding power in the servant. See Calabar Cement Company Nigeria Limited versus Daniel. See Abomeli versus NRC Supra. See also Adamo Galede versus Jebu Ode. Therefore, dismissal carries with it infamy and deprives the dismissed employee of benefit if properly carried out. In dismissing the employee with statutory labor, like the claimant in this case, an employer must communicate to the employee of the fact of his dismissal in writing. In the instant case, the employer did not do that. Rather, the dismissal was communicated to the claim and verbally by the third, fourth, and fifth defendant. This is confirmed by a failure of the defendants to produce a copy of the letter of dismissal served on the claimant. According to the defendants, the claimant was tried for absenteeism, which the claimant denied in an attempt to prove claimant was tried and found. It is in an attempt to prove claimant was tried and found guilty of absenteeism, the defendant tendered as the DWA, DWB, DWA. However, there is nothing in this exhibit to prove claimant was served with the charge of absenteeism or even invited to the hearing. Let me say here that the duty of a court is in considering the term and determination of wrongfulness or otherwise of employees' employment if the employer disagrees or challenges his dismissal from service in a court of law, as in this case, the court can only The court cannot delve into issues of whether employee was guilty of misconduct or not. The case of Tanti versus NCSB repass, where the court stated, thus, the jurisdiction of trial court is determined by the claim of the plaintiff before the trial court, and in the instant case, the claim before the wrongful dismissal from service. It is not therefore the duty of the trial court to venture to consider the involvement of the claimant in the missing package of cargo. End of quote. Therefore, if this court is to delve into the determination of absenteeism, the court will be exceeding its bound. By inviting the court to consider issue of absenteeism, the court is being asked to investigate the allegation against the claimant. Investigation is not the duty of court. The duty of court is to consider the evidence before it in arriving at a decision. All that this court is expected to do is to the duty of court is to consider the evidence before it and arriving at its decision. All that this court is expected to do is to consider the evidence before it in order to see if the dismissal of the claimant was in accordance with the regulations as contained in the Schedule to the Prisons Act and the Public Service Rules. I have thoroughly examined the relevant provisions of the prison regulation, the Regulation 82E. I have also reproduced the said provision in the body of the judgment. A careful perusal of the above quoted provisions of prison regulations, which in similar legislation will clearly show that the punishment to be imposed on the officer charged for disobedience is on the increase. Is as contained in the regulation 80 regulation 83 A to E, regulation 84 and 85. Looking at the exhibit DW2C, which contain the punishment for adjudicating after imposing on the claimant and made subject to approval and the directives of the CSP in charge of Obudu prison. The award against the claimant by the adjudicating officer is clearly in violation of the punishment for the offense of absenteeism as contained in the regulation. This is because the pay which claimant is to forfeit is more than the pay for the 3 months or double the amount by a reviewing officer. It is also clear that the adjudicating officer did not impose there is nothing before the court to show that the purported dismissal satisfies the requirement of Regulation 83E in the circumstances, even if there was proper hearing, the punishment imposed was not in conformity with the regulation. This has rendered the purported dismissal null and void. Now, I shall consider the relevant provisions of public service rules to see whether defendants have complied with the said rules. The claimant was dismissed for absenteeism under public service rules, Rules 03042A, has recognized absence from duty without leave as falling under serious misconduct, and the modus operandi or procedure to be deployed when a public it is made clear from the public service rules that a public officer who is to be dismissed must first be queried. Then, if he answers or reply was not satisfactory, he will be notified in writing of the allegation based on which he was to be disciplined. Therefore, when a disciplinary panel has been set up, he should be invited to appear before the panel. He is to call witnesses and put questions to the other witnesses that has been called against him. This is in the spirit of fair hearing. I have earlier in this judgment shown that claimant in this case was never queried nor invited to appear before any panel of disciplinary action. The action of the defendants in purporting to verbally dismiss the claimant from service clearly contravened the provision clearly contravene the provision of public service rules on discipline of employees. This means dismissal of the claimant, also going by the public service rule, is a nullity. Having found the dismissal of the claimant to be a nullity, the claimant is still a staff of the first defendant, entitled to salaries and allowances and all sundry benefits. The claimant is also seeking for an order compelling the first defendant to approve claimant's voluntary retirement and calculate all claimant's terminal benefit immediately after judgment is delivered in the substantive suit. From the evidence before the court, the claimant was transferred to Obudu and he was not given transfer allowance for him to move to Obudu. The defendants have in their evidence who deemed it fit and necessary to transfer the claimant have the bounden duty of paying claimant of his transfer allowance without him asking for such allowance. It is his entitlement which need not to be asked for. The claimant has stated that because he was not paid the transfer allowance, he put up letter of resignation or retirement, but the defendant did not approve. See Exhibit C6. He reported to Obudu on 19th day of January and was given 1 week off duty. It was also while he was on off duty that on 24th day of January 2015, he was attacked by unknown gunmen and he was rushed to the University of Calabar Teaching Hospital by the SBC7. The claimants brought, brought, brought the claimant brother notified the controller of prison about the attack on the claimant. The doctor certified claimant to be fit to return to his job on the claimant reported for duty, submit submitted letter dated 8th of August 2016, reporting what happened to him, but he was not allowed to resume as he was denied access to the office by the officer in charge of Obudu Custodial Center. See Exhibit C8. The new controller of Correctional Service in charge of correctional service in Cross River State, upon becoming aware of the predicament of the claimant, directed the claimant to resume duty, which he did, and the officer in charge of Obudu Custodial Center demand for medical report, and the claimant submitted Exhibit C12 to him. The claimant was also when it was the claimant continued to receive his salary till April 21 when it was stopped, and upon inquiry he was told verbally by third, fourth, and fifth defendants that he has been dismissed from the first defendant. However, no letter of dismissal was served on him. The defendants have stated that letter of dismissal was served on the claimant, but have failed or neglected to adduce evidence in proof of their claim. The evidence before the court is pointer to the fact that claimant was never dismissed by the defendant as a result of the purported disciplinary proceeding as per Exhibit DW2A, DW2B, and DW2C. Since he was not served with the purported letter of dismissal, this means claimant is still in the service of the defendant. Another dimension, as disclosed by the fact of this case, is the condonation of the misconduct. In the case at hand, the defendants who are aware of the claimant's misconduct, i.e. absenteeism, decided and chooses to condone the infraction or misconduct committed by the claimant. In that, the claimant's salary was restored by the defendant in January 2019. The claimant continued to receive his salary until March 2021 by the defendant. The claimant continued to receive his salary till March 2021. By this act, the defendants have condoned the absenteeism committed by the claimant. The defendants are therefore stopped from dismissing the claimant from their service. Another instance of condonation discernible from the facts of this case is the role played by the defendant for the claimant to obtain loan from his bankers, see Exhibit C18 and C19. Since the defendant are stopped from dismissing claimant from service after condonation of his absenteeism, the purported verbal dismissal communicated to the claimant on the 19th and 21st of July by third, fourth, and fifth defendant is null and void and of no effect whatsoever. Looking at all the claimant has also stated that due to non-payment of transfer allowance and stoppage of his salary in April, he handed letter of retirement resignation. The takes effect from the date of his delivery. The defendants have denied receipt of claimant's letter of voluntary retirement resignation from service. However, there is evidence the claimant's application was received by the defendant, C6 and C24, respectively. The law is well settled that the employee is entitled to, out of his own volition, to decide to retire or resign from his employment, as no employee can be forced to continue in an employment that he does not want, or to continue However, regarding C6, the application for retirement was overtaken by event in that claimant was also allowed to continue to work and his salary restored. For Exhibit C24, I find that the claimant has retired, resigned his employment with the defendant on 21st day of June 2021 as per Exhibit C24. With this finding, and in view of the case law cited, the claimant has validly resigned. There is no need to order for defendant to accept retirement or resignation appointment. For terminal benefit, the Pension Reforms Act would be assistance to the case of the claimant. The claimant is also claiming the sum of 3,152,753 naira 1 kobo. This is a claim for special damages, which by law the claimant must specially plead, particularize, and strictly prove. For the claimant to discharge the burden of proof, he must rely on the strength of his case and not on the weakness of the defense. In his attempt to prove his salary, the claimant has tendered in evidence his payslip showing his last salary and statement of account. See Exhibit C10, C23, C33 on arrears of promotion. Apart from the letter of promotion, Exhibit C3, C4, C, C10, C23, C20, C33 on the arrears of promotion. Apart from the letter of promotion, Exhibit C3 and C4, the claimant did not tender any evidence showing what his salary should be on promotion. This means there is no way of knowing the salary on promotion to calculate, to enable calculation be made and to find out the difference between the old and the new salary. The claimant, having not established how he came about the lump sums being claimed, he has failed to prove his entitlement to the claim of arrears of promotion. The claimant has onus establishing how he arrived at the lump sum being claimed. The failure to establish how the claimant came about the lump sum arrears has deprived this court of the bias to come to conclusion of claimant's entitlement to the arrears of promotion. On the minimum wage arrears, the claimant has also failed to show how he arrived at the lump sum being claimed for the claimant. To succeed, he must establish the difference between his salary and the new salary upon the coming into force of the minimum wage. Without the claimant proving what his salary is from the date of the minimum wage took effect, there is no way the court will know what the claimant is entitled to as arrears of minimum wage. The circumstances claimed for arrears of minimum wage also failed, same is hereby refused. In relief 6, the claimant is claiming 10% interest on amount owed the claimant. There is no evidence adduced by the claimant to prove entitlement to 10% interest. In the circumstances this relief failed, same is hereby refused. Relief 7 is for the sum of 1 million naira as cost of this litigation. The law is settled that grant of grant of interest is at the discretion of the court. Relief 8 is for 50 million naira for wrongful termination, wrongful defamation of character, psychological trauma, embarrassment, hardship caused by the claimant as a result of non-payment of salaries and allowances. The court, having granted reliefs on unpaid salary, cannot grant relief due to lack of evidence in proof. There is no evidence to prove defamation of character. On relief 9, payment of monthly salary allowances from the month of beginning April 2021 until judgment is delivered cannot be granted in that. This is because the claimant has wide as by the claim as by the claim as relief 10, 11 and 12 are not grantable due to lack of evidence in support. I have combed the entire proceedings and evidence on oath and under cross-examination. There is no iota of evidence in proof of these 3 reliefs. The claimant has not tendered any evidence that an insurance plan was taken for his benefit and from the insurance plan. He has also failed to join insurance company as a party in this suit. For claim on contributory welfare, the claimant has not adduced any evidence establishing existence of the scheme and what was his contribution and what he is entitled to as a contributor. He has also failed to join insurance company as a party. On cooperative society, claim of 2 million for cooperative society, the claimant has not adduced any evidence to establish being a member of that society. He has also not been able to establish the contribution he has made to entitle him to the 2 million naira. From analysis above, the claimant has only been able to prove that his dismissal from service is a nullity as the claimant has not followed due process. The failure by the defendant to strictly adhere to the procedure laid down in the prison regulation From the analysis above, the claimant has only been able to prove his dismissal from service is a nullity, as the claimant has not followed due process. The failure by the defendant to strictly adhere to the procedure laid down in the prison regulations, which is subsidiary legislation, and also lack of following procedure laid down in the Public Service Rules 2008 on dismissal has vitiated the purported verbal dismissal of the claimant. In circumstances, the claimant is entitled to be paid his unpaid salaries for the period of March 2016 to June 2018, and from April 2021 to 21st day of June 2021 at the rate of 45,542.75 per month, i.e. for 30 months and 21 days. If the monthly salary is multiplied by 30 months, 21 days, the claimant would be entitled to the sum of 1 million 397,134 naira 8 kobo. In conclusion, the defendants are hereby ordered to pay the claimant his unpaid salaries to the sum of 1.3 million naira. They are also hereby ordered to pay claimant the sum of 500 naira as cost. All judgment sums shall be settled within 30 days from the date of this judgment, failing which 10% simple interest per annum shall apply. Judgment is hereby entered accordingly.
As the court pleases.
Yes, any other thing?
No, my lord, that's all for today, my lord.
Okay. Thank you very much.
Thank you, my lord.
Come to the end of today's proceeding.
As the court pleases.